Hello and welcome back in part number 18th of the Bear Act series. In this video, we will cover from Article 116 to 120. 116 is about oath on credit or oaths of credit in exceptional grant. 117 about the financial bill. There are various type of financial bill under this article under the different clauses that I am going to discuss in this video. Apart from this article at 118 talk about rules of the procedure, 119 about the regulation by law of procedure in financial businesses. In the last one that we will discuss about article 120 that what language should be used in parliament during their businesses. Clear? So stay tuned with me till last. I am going to make it very clear for you so that you can grab it more information by simple way. Clear? Now let us discuss article number 116. But let's take a quick recap of just one article, and that article is about 115. As we all know, as I have discussed it yesterday, it contained three type of grant. One grant was about the supplementary grant. Second was additional grant for the new services. And third was excess grant if government has spent excess money on certain scheme or certain program. Then excess grant can be granted. Additional grant when there is a need of a new service to be inducted, then government can take the additional grant. And the supplementary grant, that let's suppose if the fund is become inefficient or insufficient more specifically, then supplementary grant can be issued. And the exposure of these type of grant is basically lies with the president. Now let's discuss article number 116. And this article is talk about oaths on account. What is oath on account? I will discuss it. Oaths on credit and exceptional grant. So clause 1 says that the house of the people, that means it is talking about Lok Sabha. So the Lok Sabha has the power to make what? Oath on account. That means to make a grant in advance for a part of a financial year. Suppose you are getting pocket money, right? You are getting pocket money on a daily basis. Clear? On a regular basis. But let's suppose if you need extra money for the tomorrow, and you ask to your dad or your guardian to provide the pocket money of the tomorrow to today. That means whoever giving you pocket money instead of tomorrow, you want that pocket money today because you have a extra, you can say, expenditure. Clear? Now this is same in the case of the government also. So before presenting the budget or before the passing of the appropriation bill, if government needs money, then through the oath on account, the government can take out the money from the consolidated fund of India for the certain kind of expenditure. Clear? So to make a grant in advance for a part of a financial year pending completion of the procedure for voting on the demand for grant and also passing the appropriation act. That is the simple meaning of oath on account. Then what is oath on credit? So let's suppose if government has an unexpected demand upon the resources of India, and to make or to meet that unexpected demand, oath of credit type of grant can be issued. That means let's suppose when a magnitude or indefinite character of the demand is such that it can't be stated with the details ordinarily given in the budget. Clear? What is it? So it is just an unexpected a large financial demand arises and its exact detail can't be given in the normal budget. Then government has a device called oath on credit, sorry, oath of credit. Okay, so if there is an unexpected demand and government wants to meet that certain kind of demand, then without giving the details of that particular grant, oath of credit can be used as a device for the government or by the government. Clear? So oath of credit is about the unexpected demand, and oath on account is about the advance before passing the appropriation bill or even before the presenting the budget for that financial year. One is exceptional grant. What is exceptional grant? For the exceptional purposes. So if money is required for a special purpose that is not part of a normal service of that financial year, then a special grant can be issued. But as I have already mentioned it, that it is on the dispose of the Lok Sabha. Council of the people can be vote on credit, votes of grant and the exceptional grant. So vote on account is temporary because government is going to present the budget and also going to introduce the appropriation bill to take out the money for certain expenditure. But before that, you can take out the money by using the vote on account. And second was, if there is an unexpected demand that came to the government of India, and to meet that unexpected grant, the government can take out money. Clear? And that is by the vote of credit. And for any special purposes or during the any special circumstances, if there is a need of money to the government of India, then government can use exceptional grant. So these three devices are mentioned in the article number 116 clause 1, and these devices are available to the central government. Clear? Clause 2. This clause or this provision is simply related to the procedure in the parliament, and the consolidated fund of India shall apply to these grants as they apply to grant made under article 113 and appropriation under article 114. Simple meaning that these special grant still have to follow the constitutional financial procedure. That means you have to introduce a bill. Clear? To take out the money if you are using these type of grant, vote on account, vote of credit or exceptional grant, that need a special procedure. Clear? So this is about the clause 2 of the article 116. Now let us move to next article 117, and this article is about the special provision for the financial bill. As in my yesterday lecture I have told you that all the money bill is a financial bill. All the money bill is a financial bill, but all the financial bill is not a money bill. That is the most important information regarding these bills that you should keep in mind. Now let us discuss clause 1. So let's suppose if a bill or let's suppose amendment making a provision for any of the matter that are mentioned under article 110 about the money bill, clause 1a to f, means there are certain matters that are mentioned under article 110 clause 1 subclause a to f. Clear? So bill or amendment making provision for any of the matter that are mentioned under article 110 to f, then shall not be introduced or moved except on the recommendation of the president. Apart from this, such bill shall not be introduced in the Rajya Sabha also. It only be introduced in the Lok Sabha. That means one important thing is that no recommendation is required for moving an amendment that provide for the reduction or abolition of taxes. That is, for a certain financial matter, president's recommendation is required, and a bill if dealing with the matters under article 110 clause 1 subclause a to f, then these needs the recommendation of the president and it can't be introduced in the Rajya Sabha. But if an amendment is seeking to reduce or abolish a tax, and this amendment not require the president's recommendation, that is the basic difference. So article 117 clause 1 talking about the that under what circumstances you will introduce the money bill or the basically bill related to the matter mentioned in the article number 110. Clear? Clause 2. Clause 2 says that if a bill is not treated as making a provision for the matter mentioned above, merely because it provides for fines or other pecuniary penalties, fee for license or services, imposition, abolition, remission, alteration, everything I have discussed yesterday. So just because a bill contains fine, fee, local tax, it does not automatically become a bill that requires special treatment under article 117 clause 1. It means the matter that are mentioned under article 110 clause 1 a to f, if a bill is introduced relating to that matter, that bill only considered as a money bill, and that required a special provision, and that special provision are mentioned under article 117 clause 1. That what makes article 117 special. So clause 3, a bill which if enacted would involve expenditure from the consolidated fund of India shall not be passed by either house unless the president has recommended to that house for the consideration of the bill. Simple is that if a bill require money to be spent from consolidated fund of India, then prior approval of the president is necessary. That means president's recommendation required before the bill can be passed become necessary. Clear? So it is mentioned under article 117 clause 3 that you should keep in mind. So if you think, if you look, article number 17 is about the detailing of the article number 110. Clear? That you should keep in mind. So if government want to take out the money from Consolidated Fund of India by introducing a bill, then the government needs prior recommendation of the president. Clear? And if a bill is not covered the matter mentioned under Article 110, that bill will not consider as a money bill that is mentioned under clause 2. Clear? So this was about the article number 117. Let's move to article number 118. It is talk about the rules of the procedure. So each house of the parliament may make rule for regulating subject to the constitution, its procedure and conduct of the business. Let's suppose that there are students who are currently studying in different classes, and different classes make its own rule to manage the classes when there is teacher basically absent. So different classes may have a different rule, and it should be within the class, or class should have a authority to draft that type of rules. It is also true in case of parliament as well. Lok Sabha and Rajya Sabha both have a power to make rules for themselves. That is the basic of the article number 118. So each house of the parliament, that means Lok Sabha and Rajya Sabha, if they want to make rules for regulation, but it should be subject to the constitution, its procedure and conduct of business, that then houses can make rule for themselves. Clear? So Lok Sabha and Rajya Sabha can make their own rule for how proceeding will be conducted, how business will be carried out, and the other parliamentary procedure as well. So each house has the authority to make the rules for themselves to carry out the transactions of the business of the houses. Clause 2. If suppose that if any house is not able to make the rules to carry out the transactions of their house, then until rules are made under clause 1, the rules of the procedure and standing order existing immediately before the commencement of the constitution shall continue, but it should subject to necessary modification and adaptation according to the time. Clear? So if, let's suppose, due to any reason, if house is not able to make rules for their transaction or for their proceeding in the house, then the rules that existed just before the commencement of the constitution, that rules shall be applied to that house. It is mentioned under article 118 clause 2. Clear? So until parliament make its own rule, existing rules can continue with necessary changes that required according to the time. Clause 3. The president, after consultation with the chairman of the council of state, that means Rajya Sabha, and speaker of the house of the people, that means Lok Sabha, may make rules regarding the procedure for a joint sitting. As I have discussed yesterday, both houses have the authority to make the rules for themselves, but which house rules will follow in during the joint session basically, then it is totally upon the president. President, after consultation with the chairman of the Rajya Sabha and the speaker of the Lok Sabha, will make rules regarding the procedure for the joint sitting. Clear? So for the joint sitting, it is totally upon the president. But for the Lok Sabha, they can make their own rule. For the Rajya Sabha, they also can make their own rule. But for joint sitting, it is completely upon the president. And president will make rule for the transactions or the procedure of the joint sitting. But president will consult deputy chairman of the council of state and the speaker of the house. Clear? So for the matter that are concerning with the joint sitting and the communication between two houses, then president is authorized to make the rules after consulting chairman of the Rajya Sabha and the speaker of the Lok Sabha. Clause 4. At the joint sitting of the two houses, the speaker of the house of the people shall preside, or in his absence, such person as may be determined by the rule. So who will preside over the joint sitting? It is speaker of the Lok Sabha who will preside over the joint sitting. And if suppose if speaker is absent, then the such person as may be determined by rules of procedure made under clause 3. That means president. So president will authorize a person, or the president will make rules that if suppose a speaker is absent, then who is going to preside over joint sitting? Then according to that rule, that person will preside over the joint sitting. That is the simple meaning. It is provided under article 118 clause 4. So article 118 contains 4 provision. The provision 1, that each house has the authority to make the rules for themselves. Until clause 2, until the rules made by each houses to carry out the transactions of the business, then the rules that are existed just before the commencement of the constitution, that rule will apply. And clause 3, that president has the power after consulting with the chairman and the speaker to draft the rules for the joint sitting. And clause 4, that who will going to preside over the joint sitting? Speaker of the Lok Sabha, because Speaker is the member of the House of People and Chairman is not the member of the House Council of the state. That's why Speaker will preside over the joint sitting. But if Speaker is absent, then the rules that are made by President under clause 3 of the Article 118, such person is authorized to preside over the Lok Sabha. That is the simple meaning of the Article 118 clause 4. Now let's discuss Article number 19. In this article is about regulation by law procedure in Parliament in relation to the financial businesses. So Parliament may, for the purpose of ensuring the timely completion of the financial businesses, regulate by law the procedure and conduct of business in each house relating to financial matter, or if any bills for the appropriation of money from the consolidated fund of India, or if such a law is inconsistent with the rule made by House under Article 118, then the law shall prevail. Let us discuss and make it more simplified. Clear? So Parliament has the power to make a law that ensure that financial businesses should be completed on time. Clear? So who has the authority? Parliament has the authority to make the law. For what? To ensure that financial businesses should be completed on the time. And if there is a conflict between parliamentary rule under Article 18 versus laws made under Article 119, that means Parliament's law, then Article 119 will prevail. Clear? So Article 118 is about the rules and 119 about the laws can regulate financial procedure, and the law making power is with the Parliament and the rules making power lies with the respective house, and for the joint sitting it lies within the president, who will draft the rule, who will make the rule after consulting the chairman of the house of the chairman of the council of state and speaker of the house of the people. Clear? Article 120 and last article for today, language to be used in the Parliament. Clear? Notwithstanding anything in part number 17th, but subject to Article 348, business in Parliament shall be transacted in Hindi or English. And the chairman of the Rajya Sabha and also this power available to Speaker of the Lok Sabha. And if they think, then they can permit a member who cannot adequately express themselves in Hindi or English to address the house in their mother tongue. Let's suppose if there is a tribal MP who not know the Hindi or English as well, they know their own language, then it is totally upon the presiding officer to allow such person to speak in their own language or their mother language. So it is mentioned in the constitution under Article 120, but for that Hindi and English is general language that should be used in transactions of the business of the Parliament. So for the normal parliamentary business, Hindi or English, but if a member is unable to speak Hindi and English, then presiding officer has the power to authorize that person to speak in their mother language or the language they know. Clear? So Hindi plus English, main language of the Parliament, and mother tongue may be permitted by speaker or chairman. It is mentioned under article number 120 clause 1. So what is clause 2? Unless Parliament by law otherwise provide, Article 120 shall, after the expiration of the 15 years of the commencement of the Constitution, operates as if the word or in English were omitted. That means that this was the constitutional original transitional language provision. But if the Parliament think that we should make a law for the languages to be used in the Parliament, then Parliament has the power to make that law. Clear? So Parliament subsequently provided for the continued use of English through the law. So in practical term today, Hindi and English are to be used in the Parliament, but Parliament has the power. If the Parliament think that no, we should continue in Hindi but not in English, or we should continue in English but not in Hindi, then Parliament has the power to make the law. Clear? So this was about Article 120 about the language in Parliament. So let us take a recap. Article number 116 about the vote on account, vote of credit and exceptional grant. Article number 117 about the financial bill. Article number 118 about the rules of the procedure. Each house has its own rule making power, joint sitting by president. And the Article 119 financial procedure by law, that is power lie within the Parliament. And Article 120 what language should be used in the Parliament. Clear? Vote on account means advance grant for part of a financial year before presenting the budget. Vote of credit, unexpected demand, exceptional grant for the special purpose. Article 117 special provision regarding financial bill, and 118 houses make their own procedure rule. Clear? So I have discussed it in detail clause by clause. I am not sparing anything. I have covered everything. Clear? And if you have doubt, let me know in comment section. And if you want to give any type of feedback, then also you are welcome in comment section.